So anyhow, because it's always a fun time. We always do things. We tend to do and be fun and all that kind of stuff. So anyhow, hey, out there in spray wash land, we're going to get ready to go here pretty soon. And we're going to talk a little bit about branding today. And that should be a fun discussion. And I do want to bring up that some of this is coming through from Landon. And I'm thinking he'll join us today, and we'll get into some different topics and different things. And we'll kind of go over all kinds of stuff. But our special guest today, and I'm going to ask you a question just so you know that I haven't prepped you for, and okay. I'm going to see how you answer it and see if you get the answer right. I just want you to know that this is a test. Okay. So, Mr. Roland here. So let me see if I get your last name right. Sennholz. Is that right?
Good.
Okay. Yep. So it's Roland Sennholz, Esquire. Okay. So you tell me what Esquire means.
Esquire means that you are licensed to practice law somewhere in the United States.
That's not the answer I was looking for. I'm sorry you got it wrong.
Okay.
So Esquire also could mean, right? How does it go? It's that you're training for knighthood. Did you know that? Esquire.
Oh, okay.
So I was hoping that you were training for knighthood.
Yeah, that's what the show was about. It's not about this legal stuff, but anyway.
I mean, my name is Roland. I'm Charlemagne's right-hand man was named Roland. There might be something going on there.
There you go. So, Mr. Roland, tell us a little bit about you and the company that you work for and what it is that your company does. And then we're going to get in. We're going to start talking about branding. So tell us a little bit about yourself.
Okay. Yeah, so my name is Roland Sennholz. I work at Argent Place Law, which is a law firm in Falls Church, Virginia. We're basically Northern Virginia, just outside of DC. And we help entrepreneurs with basically all of their red tape. When you get a business started, you're going to need probably an LLC. You're going to need some contracts, maybe a trademark, probably a trademark. That's what we're here to talk about tonight. Mm-hmm. And just some other random paperwork and industry-specific questions. And so it really helps to have someone who can actually listen to what you're talking about, listen to what you're doing, and then give advice on what to do to not break the law and maybe even prosper and succeed along the way. So we help with all of that. And I've been working with the firm, I think we're past 4 years at this point, and just helping entrepreneurs with all kinds of things. So I have helped people start everything from a preschool to a whole bunch of government contractors and speaking kinds of businesses, a couple tech companies, one whiskey distillery. That was kind of fun. And just a bunch of different companies. So looking forward to it today.
Well, and one of the things I can tell you right now, you'll get lots of questions probably. And the first question that I saw right off the bat is something that I intended to cover anyhow. And this is coming from Matt Matheson, who is saying, so if someone used a picture that they stole in an ad, can you sue for income generated during the time the ad was ran?
Well, it's going to depend on a couple of things. And actually, okay, so before I start answering all the questions, I do want to add my own star.
Legal disclaimer.
Yes, disclaimer. I love disclaimers because that's part of my job description. So I am a lawyer. I am not your lawyer. You may want to consult with a legal professional on the specific facts of your case before you just kind of take what I'm saying and go run with it. And
you're doing a generalized thing, not a honed in thing on your particular problem.
Yes.
And none of you are clients.
Right. I'm going to try and answer in broad strokes rather than in just like this one specific case. Mm-hmm. Generally speaking, so a picture, if someone used a picture that they stole in an ad, a picture that they stole. So I'm assuming then that you own the picture, right? You have a copyright to it. You have registered that copyright with the U.S. Copyright Office.
That's the question.
Okay, that's the question. Do you actually own the picture, right? If someone else steals your picture, then and you own that picture, then there are a couple of different kinds of damages you can pursue. One of them probably is the income generated during the time the ad was run, but there's also a thing called statutory damages, which is how they nail people who take music and then they post it on Facebook or whatever. Every time someone listens to that song, if you've like stolen a song and put it online, that's one infringement. And the statutory damages that you can get for copyright infringement are up to $150,000 per infringement. Okay, so they don't mess around when it comes to copyright infringement.
But does that have to be something that you filed a copyright on, or go ahead?
So copyright is one of these rights that's kind of you get it when you create the work. Technically, you own copyright in something as soon as you create it. But in order to actually get those statutory damages that I was talking about, you want to have registered the copyright either before the infringement took place or within a pretty short window after it took place. Mm-hmm. So you have to have it registered if you really want to do the most you can with it.
Mm-hmm. We had a very well-known picture that we used for years, and it was on the rear of all of our trucks. And I went ahead and took the steps of getting that picture copyrighted. And it's ironic now. I go out and I'll do a reverse image search, and I find where this photo has been used literally hundreds of times by people that are not me. And I've always wondered, would that be a fun retirement program of just because, I mean, I've got the copyright, number on those two, and it's not just one, but it's two separate images because it's a before and an after taken at separate times. And I was thinking, man, I could just bang this out for $300,000 a pop from everybody.
Well, maybe, but here's the thing: you're gonna be running how many lawsuits for how many years?
Yeah, exactly.
With people that have no money, probably.
Yeah, true. They didn't have enough business to take their own damn pictures. Yeah.
And that's the other piece of it, right? Like, okay.
Well, let me ask you this: what if you put a watermark on the photos? And let me make it a two-part question. What if you put a watermark on the photos, one, and then number two, what if they remove your watermark from the photos?
Well, neither of those. Okay, so if you have a watermark on the photo, right, and then they copy it, so the watermark pretty much just makes it easier to prove that they copied your photo, right? If the one that they have has the same watermark as you, then it's pretty clear, it's pretty obvious that, okay, they got it from here. If they go in and they alter, manipulate, remove the watermark, then if you can prove that they did that, that doesn't necessarily affect whether it affects damages, right? It affects like, okay, this person didn't just steal the picture. They knowingly stole the picture and then tried to cover it up.
Right now, it's almost like a malicious intent kind of thing.
Exactly. It goes to show that they weren't just kind of like, oh, let me download a random picture off the internet. They actually went and stole something and then tried to make it.
Ironically, we've seen this in this industry. We've actually seen this more times than I really care to admit from some of my people, not my people, but people that are in this industry where, oh, that's a great looking picture. I'm just going to crop out this top corner or bottom corner that has the logo on it, which is just horrific, to do. I mean, it's one thing to go and steal a picture, but it's really, really bad whenever you go and take someone's watermark logo out of the picture and use it.
Yeah, exactly.
So here's a legal question.
To the random comment here that asks if I'm Jared Kushner. No, I'm not Jared Kushner. I did get that about once a week back when he was in office, before COVID anyway. But yes, I know there's an uncanny resemblance. thanks / sorry /
We
whatever.
paid him to say he's not Jared, just so you know. We paid him to say he's not Jared.
Well, Jared's not doing a lot these days, so you know. What steps do I need to do to switch a DBA to an LLC, and what benefits would there be?
Okay. I'm going to try and answer that quickly because there is one more thing on the whole before and after picture, or I'm assuming they're before and after picture.
We can come back. We can readdress this.
Either way.
Let's. Oh, okay. Okay. I was going to say we can just come back to that, but okay. So I'm assuming there that it was like before and after pictures or something like that, not a branding item, right? It was not like your logo. It was not a picture that you use to advertise your services. Like this picture is synonymous with my company. It was more kind of a results thing, right? That's where.
But he did use it in advertising because it was on the back of his trucks, and he used it in advertising forms.
Sure. Okay. Okay. Copyright is a good way to protect pictures, other things of artistic books, right? Artistic expression is what it's supposed to protect. Trademark is supposed to protect logos, names, brands, anything that is kind of synonymous with your company. Okay, so you could trademark a picture. If you use it as advertising on the back of your truck, you could totally trademark it. You're going to get different. It's going to be easier or harder to protect one image or another depending on what it is what I'm trying to say. Don't assume that because it's like a before and after picture, it must be copyright. Don't assume that because it's a logo, it must be trademark. It also depends on kind of what you're trying to accomplish with it.
Hold on. You just reminded me of something. I looked over and said, an idea here. So this is a device that we use in our industry called the proportioner. And I know that the inventor has trademarked this logo. He has trademarked this logo right here. The proportioner trademarked the name, and then has also filed for patent protection on the process of this whole box. So he's taken multiple steps on there to really lock up both the name, the box, and the process of doing it, and the artwork.
Would you like me to do like a really brief summary of patent, trademark, copyright, and kind of what the differences are?
Sure. You're the boss. Run with it.
Well, okay, because we're talking about brand protection, right? Patents are a little bit outside of that, but since we're talking IP anyway, there are really kind of four main pieces of intellectual property. Okay, there are patents, which are designed to protect something that is functional, right? It is a method of doing something. It is a design. It is it's a device of some kind, usually. Right? Could be a box that has valves and specific things inside of it to make it work a certain way. Could be a smartphone. Could be whatever, as long as it does something. Earlier today, I was dealing with a client who has a patent on one of those baby backpacks, right? Where you can carry your baby around. And so it's a device, right? It's designed a certain way, and the design of the device makes it useful for a certain function, which you can protect through patent. Copyright is designed to protect, the legalese is an artistic expression fixed in a tangible medium. Okay, so the idea is you have something that requires a bare minimum of creativity. Something that requires a bare minimum of creativity. Could be a song, could be a picture, could be a movie, could be code, software code, could be whatever, but it requires a bare minimum of creativity, and it is actually fixed in a tangible, it exists somewhere outside the person's head. So that, for example, there was a copyright case a while back where a fellow sued, I think it was George Lucas or Lucasfilms, whatever. He sued them basically saying, oh yeah, the AT-AT walkers in Star Wars, right? The big four-legged things, tanks with the lasers on the nose. Those are actually a copy of my Garthian Striders that I came up with several years before the Star Wars movies ever came out. And basically the trial, to boil it all down to one or two sentences, the trial went something like this. Great, do you have any proof that you came up with that before Star Wars? Well, I had some documents, but they were destroyed. So no. Yeah, no, not really. Okay, dismissed.
Pretty quick and easy.
So the copyright can't just be for like, oh yeah, I had an idea for a story about a super detective. You have to write it down. It's like, okay, his name's Sherlock Holmes. He did X, Y, and Z. These are his adventures. Now you get the copyright protection. You can't copyright a title. Yeah, you can't copyright a title. It's too short. Usually, there's not enough information. But you can copyright usually a picture. You can copyright a bunch of different things. There was a lawsuit pretty recently about what happens if like who owns the copyright. So there was a chimpanzee that got a camera away from a photographer and ended up accidentally taking a selfie. And the question was, who owns the copyright? It wasn't taken by a human. So there are a lot of weird and interesting questions that come up here, but they're more interesting to people who like to basically build Legos in their mind than to other people sometimes. So I'm going to
Get into all that.
And I probably could answer that because in Florida, pigs have constitutional rights as agreed upon by our voters back 20 years ago. So I have a feeling in Florida, the chimpanzee would own that.
Interesting.
It must be state constitution.
Is that Florida? Or is that California?
It's our state constitution.
Okay.
Whenever voters want to do something in Florida and they can't get, and unfortunately they just make a constitutional amendment to it. So our constitution is just rife with ridiculous. When they couldn't get marijuana laws passed, they changed the constitution. When they wanted, they thought that the way pigs were raised were cruel. They literally gave pigs rights, or I shouldn't say they gave them rights, but ostensibly gave them rights because they regulated the way that pigs had to be raised, named in the Florida Constitution. It's really kind of goofy.
So let's go back to that question you had, Ray.
What's that?
The one that was on the side.
The LLC.
The LLC question. Let's go back.
And then we'll get into some of Landon's questions.
Yeah. What steps do I need to switch my DBA to an LLC?
And what's the
did I drop out? Can you still hear me?
No, you're there.
Okay. My video dropped for a second. So to switch your DBA to an LLC. So a DBA is okay. Okay. I'm trying to figure out whether to answer the question you asked me or the question I think you're really asking. So when you start a company, if you don't register with the state, okay, it is what we call a proprietorship, right? At least for IRS tax purposes, it is a proprietorship. It is basically kind of an extension.
There is no DBA.
There's no entity.
There is no DBA because you don't have a business. In order to have a DBA, you've got to be a company, corporation, or an LLC to do a DBA. Is that where you're at?
So you can have a DBA. So if you are operating a business under a name and the name, and you don't have an entity, but you just are using that name, then that is a DBA. It just kind of points back to you. Mm-hmm. Okay. Normally, when I think of a DBA, I think of you have an LLC, you have something registered with the state, and then you want to rebrand or you want to open a second line of business under the same LLC, but have it have a different name, right?
So I can give you an example. Whenever we sold our company, Spray Wash Exterior Cleaning, we actually then changed the name of that corporation, did a legal name change to RT Burke Consulting, which is my wife and my initials on there. And then we have a separate DBA as Power Wash Store Tallahassee on there.
There we go. So I think of a DBA as kind of like a desktop shortcut, right, on a computer, or a pointer, right, like a it refers to something else. Okay, and so a DBA is kind of usually it's something you file with the state. Sometimes it's something you file with the county. It depends on what state you're in, but it's something that kind of serves to let the state know that this is another official name for this same company.
Mm-hmm.
Usually where I see people requesting a DBA or needing a DBA is if they're going to start a second completely separate line of business in the same company, or if they are trying to take payments under that DBA, under that trade name, and their bank requests, hey, can you prove to us that name actually corresponds to your LLC?
We just ran into that where we had to go because we're getting checks into Power Wash Store Tallahassee, and we go to deposit them, and they're like, well, your account says RT Burke Consulting.
There we go. Yep. And bank lawyers are like that. They want to be sure that everything is on the line.
Could I get you
the way it's supposed to be?
To speak then to the other end of this question. So, but basically, so if you're just doing a DBA without an LLC or without any type of the corporate, just a sole proprietorship.
Yep.
Could you speak to just how you literally have no protections and you are liable probably for lots of horrible bad things that could happen? And what is this protection that an LLC does for you?
Why incorporate? Yeah. Okay. So it goes back to liability. Okay. Let's say that something happens while you're on the job. You're pressure washing and some idiot sticks his hand right in front of the nozzle. You're whatever, you're doing something and someone gets hurt. Okay. They now bring a lawsuit against the person who hurt them. Right. Okay. I guess we'll run with my example. They stick their hand in front of the nozzle. You hurt them because you weren't careful enough to make sure that they didn't put their hand in front of the nozzle, and therefore you were negligent. Dumber arguments have been made. So they say, you're negligent and you owe me millions of dollars because I'm missing all my fingers now. Whatever. The lawsuit then proceeds, and the jury says, for whatever reason, yeah, we agree. You owe that person millions of dollars for the harm that they came to because of this accident. Now, here we come to the fork in the road. If who this person sued is you personally because you were using a DBA, right? It was a proprietorship. It was basically just another name for you. Then they're suing you personally. And everything that you own is now something that they can come after for that judgment, for that debt, right? For the lawsuit. When you win a lawsuit and you get a monetary award, it's called a judgment. So they can come after you for that judgment, and anything and everything you own, your home, your car, your pets, whatever. Well, maybe in some states, unless they have constitutional rights, like pigs in Florida, or whatever. But they can come after your property for to satisfy that judgment, right? If, on the other hand, we could take the other fork in the road. Let's say that you incorporated before this accident happened. Well, now you weren't really there pressure washing as you. You were there pressure washing as kind of an extension, an agent, right, of the LLC. You were there on behalf of the company. which means that the responsible person is not you, it's the company. And then they can go after the company, or they would have to go after the company. Most of the time, it is not possible to go after the person who owns a company. It's only possible to go after the company. Unless you can prove fraud or something else pretty serious, you can only go after the company, not the person, not the owner.
Well, let me ask you this then, because my attorney scolded me pretty hardcore on piercing the corporate veil. And I think a lot of small business owners are very, very guilty of doing this. Of my business checking account is also my personal piggy bank, and I'm out doing, okay, I need money here. Let me just go to the business account because I haven't paid myself a check. And so now I've got a record of financial things, and I'm buying myself a lot of personal stuff on my business account. So that is now what we're calling piercing the corporate veil. Is that the terminology I'm hearing there?
That is the terminology. Yep. So piercing the corporate veil is the term for what happens when you sue the owner of the company and you try to say, well, the company isn't really, it's a sham company kind of. It's there to
shield you,
to let them do stuff without any consequence, rather than actually being a legitimate company. And there are a couple of things that you usually use to try and prove that. And you just named one of the top 3 mistakes that I see entrepreneurs make. And that is that they don't treat the company like a separate entity, a separate person, basically. When you have an LLC, right, it provides this wonderful protection because let's say that they get a judgment against the LLC, they can only fulfill that judgment with the LLC's assets. If the LLC runs out of money, then too bad. The rest of their judgment goes unpaid, goes unfulfilled. They can't come after your house or your car or your pet or whatever unless those are owned by the company too.
And there's where the problem is if you keep all of your stuff in the name of the company.
And so to go back to the piercing the corporate veil question, the top 3 mistakes, sometimes we see entrepreneurs who have a company, right? They have an LLC, and they maybe even and they either don't set up a separate bank account for the LLC. They just use their own personal account, or they do set up a separate account, but then they don't keep the wall there. They don't keep it separate from their personal stuff. They use the company money to pay personal debts, or they use personal money to cover. They don't carefully, they don't ask, like, okay.
They're commingling. They're commingling their funds.
Yes, the technical term is commingling.
They're writing a personal check, let's say, to the power wash store instead of a company check to the power wash store. When what they should do is write a personal check to the company and then let the company write the check and then that way they can show it as a loan to the company, and then the company makes the payment to the power wash.
Or I go out for a really nice dinner and I can't prove that we've actually discussed business, or I've taken other pressure washers or customers out to that dinner, and it really turns out that it's just me and my wife going out there doing it.
Well, although, that one's a little bit, that's up to your tax professional a little bit, because I know that let's say that, I don't know if it sounds like you and your wife are in business together.
Right. Well, yeah, it's a little bit, I'm not a good example of that, but.
Okay.
Yeah.
Well, what I mean is, if you go out to dinner with your wife and you at least talk some business, now it could be a business expense, right? It could potentially.
Check with your tax professional.
The rules, yes, check with your tax professional, because the rules around meals, especially, are fast moving. They change often. Before COVID, it was like, I think when Trump came into office, they actually reduced the amount of stuff that you could do on meals and entertainment. Then COVID happened, and then they said, you know what, we need to save the restaurants. Let's make meals deductible again. And so they changed it back, and I don't know where it is now. So check with your tax professional, because those rules change quickly.
All right, let's head back towards the branding side, because that's what we're supposed to be talking about. This is common for us. We don't necessarily follow our forum every time. So I want to get into a couple questions that Landon had asked and thoughts that he had brought out. And I think that they were really good. And I think they're things we should talk about when you look at the branding side of things. So one of the things that Landon said was, if you want to name your business the same as another business, don't do that. Okay. Choose another name. If you take a name thinking it's not a big deal because of geography, so let's say you're in Alaska and they're in Florida, that's still not a good thing. So because of geography, you're wrong. It's a big deal. Google will populate all names. There is a specific search. Let's see. The customer is left to call the wrong business or discern what business is which one. Okay, so if you're naming it I'm just going to pick on the Power Wash store. So if you're calling it the Power Wash store, and there weren't all the franchises and all that, but there were a Power Wash store that started in Milwaukee, but then another one decided, hey, I like that name, I'm going to take it because it's available in the state of Alaska. That's a bad thing to do. What do you think about that?
It is kind of a bad idea. So trademarks are, generally speaking, right, you want to get a federal trademark if you can. Okay, a federal trademark is a lot stronger than not having a trademark at all, and it's even stronger than having a state trademark. So a federal trademark protects you anywhere in the U.S. Even if you are in Alaska and the other person is operating in Florida, then theoretically there's a collision there. If one of them owns a trademark, then he can ask the other one to change names. Could you actually force that in a lawsuit if you were to really have a knockdown, drag out fight about it? That one's a little bit iffy. It's going to depend on the facts, but generally, but you could at least make a demand, right? You could at least say, hey, you're using my name, knock it off. And in fact, a trademark gives you a couple of things that you can do that not everyone knows about. Okay, so one of my favorite things to do when I'm sending someone a cease and desist letter, hey, you're using our client's trademark. I understand that neither you nor my client wants there to be customer confusion. We don't want your customers going to the wrong people. You don't want your customers going to the wrong people. But here in this particular instance, my client actually has a federally registered trademark. So would you please be the one to change your name? Or else I will submit takedown requests and ask Facebook, Instagram, Twitter, and everyone else.
Everybody else shut you down.
Yeah. Because that's something you can do. That's something you can do with a federal trademark. You can basically submit requests to Facebook, Instagram, whoever you want, any of the big platforms, and say, this content infringes my trademark, please remove it.
What about doing that? That could potentially be more devastating than a lawsuit, really.
Yeah, you're just all
that's why I use it, is because you threaten to sue someone, and they're like,